Today we present a special encore presentation of Jessica Aldridge's interview with human rights attorney Steven Donziger, recorded in December 2020. We investigated the story of Chevron's crimes in Ecuador with Mr. Donziger, who represented Ecuadorian communities demanding justice in a $9.5 billion decision against them for one of the largest ever oil disasters. This was recorded while he was in his 16th month of house arrest for litigating said case. And he ultimately served 993 days at home and in federal prison for a misdemeanor charge that usually requires a maximum of 180 days. Well, we begin with an introductory excerpt from a Vice video entitled "The World's Worst Oil Disaster You've Never Heard of." Thank you for listening to Eco Justice Radio.
I always remember a story Umberto talks about a lot of how when he was a little kid, there's an enormous river in front of the village where he lives in the forest, and one day it just became absolutely riven with black oil. When you see the river on fire that your people have depended on for 1,000 years because of oil contamination, you see your life and your future go up in flames.
What some environmentalists call the world's worst oil-related disaster.
My name is Steven Donziger. I was there in Ecuador when indigenous groups and Amazon communities were fighting Chevron in an epic battle for justice. My first trip to Ecuador was in April of 1993. I went down with some lawyers and scientists to investigate reports that Texaco had dumped literally billions of gallons of toxic oil waste into the pristine Amazon rainforest where indigenous groups live. No one really knew what would happen as a result of the trip, but one thing that did happen is those who went on it all committed to trying to do something to address the problem and to help the people, and to hold Texaco, now Chevron, accountable for what looked like a massive human rights problem that was done deliberately.
Hello, and you're listening to Eco Justice Radio, a project of SoCal 350 Climate Action. Our show presents environmental and climate stories from a social justice frame, featuring voices not necessarily heard on traditional, mainstream, or even public media outlets. I am your host, Jessica Aldridge from Adventures in Waste. This is part 2 of our special 4-part series called the Amazon Defenders. On today's show, we discuss criminalizing activism, the Steven Donziger case, and we are lucky to have Steven with us on the show today. Steven Donziger is a New York-based attorney, human rights advocate, and a member of the international legal team that won the historic $9.5 billion Ecuador pollution judgment against Chevron. Welcome to the Eco Justice Radio special 4-part series called Amazon Defenders, where we will break down the environmental and indigenous issues happening in the Amazon rainforest, from the oil exploitation in Ecuador and the Western Amazon to the impacts of deforestation, fires, and COVID in Brazil and the Eastern Amazon region. Today on part 2 of Amazon Defenders, we investigate the story of a New York-based lawyer, Steven Donziger, who represented Ecuadorian communities demanding justice from Chevron-Texaco for one of the largest ever oil disasters, also referred to as the Amazon Chernobyl. We have a pretty powerful show today. Our guest story is quite remarkable, and you could even say unbelievable. It seems much of the corporate-funded media and even many of the public media and nonprofit outlets who, let's be honest, still take money from oil and gas interests, are not covering this story. And if they are, it's slanted in favor of Chevron. In an historic judgment, Chevron was found liable by Ecuadorian courts in order to pay $9.5 billion. Chevron says, nope, they'll never pay. Instead, Chevron launched an extraordinary racketeering and extortion lawsuit against the Ecuadorian and U.S. attorneys and various consultants, alleging that they are all lying about Chevron's pollution and that the entire case was sham litigation. Chevron has turned our guest, Steven Donziger, into a corporate political prisoner, and they are using retaliatory attacks to intimidate the Ecuadorian indigenous peoples and farmers who have been harmed by the oil giants' massive contamination of their ancestral lands. This is a special encore presentation of our interview with human rights attorney Steven Donziger, recorded in December 2020. In a move calculated to shield Chevron and deter other lawyers from suing giant corporate polluters, Donziger was sentenced on October 1st, 2021 to the maximum of 6 months in prison for criminal contempt. In our interview, Steven talks about the case, what actually took place, the historic retaliation against himself and the Ecuadorian peoples, and how Chevron's actions set a dangerous precedent and represent a growing and serious threat to the ability of civil society to hold corporations accountable for their misdeeds around the world. Thank you for tuning into Amazon Defenders, Criminalizing Activism, the Steven Donziger case. It is my honor to welcome our guest, New York-based human rights attorney, Steven Donziger. Welcome to Eco Justice Radio.
Thank you. Thank you for having me.
Thank you for being here. Steven, let's start out by setting the scene for our listeners so that they understand what brought you down to Ecuador in 1993 when you were part of the team that filed a class action lawsuit on behalf of 30,000 farmers and indigenous peoples against Texaco for the polluting of an area of the Western Amazon referred to as the Amazon Chernobyl by locals and experts. Explain what happened to the people and the land and why there was and is this lawsuit.
Well, thank you for having me, Jessica. I mean, it's a long story that spans over 25 years. I'll keep it real simple. The bottom line is Texaco, now owned by Chevron, went into this delicate ecosystem, the Amazon in Ecuador in the mid-1960s. They found oil. They had a contract with Ecuador's government to drill across an enormous 1,500 square mile area of forest that was home to 5 indigenous nations. And they discovered oil in the middle of Kofan territory in 1967. They built hundreds of wells over the next 20 or so years. They built about 1,000 unlined waste pits into which they deposited drilling muds, which are cancer-causing, toxic chemicals or heavy metals found in the ground when you drill for oil. They ran pipes out of the sides of the pits into rivers and streams that the local indigenous peoples and other farmers that had moved down there relied on for their drinking water, their bathing, their fishing. And essentially over, the 25 years they operated, from the mid-60s to the early 90s, they engaged in a deliberate mass industrial poisoning. When I say deliberate, they deliberately polluted to save money. It was clearly foreseeable that the result would be a lot of people getting sick, getting cancer, and dying. And they didn't care. When the indigenous peoples of the area, saw, in the 60s, early 70s, what they were doing, and they asked the Texaco engineers why black oil was in their streams and rivers, the engineers reassured them by lying and basically saying oil was medicinal, and it was like drinking milk with vitamins in it. It was healthy for them. It was a complete and utter disrespect for these people who live there, for humanity, for the earth, for basic decency. It was also blatantly illegal and criminal. So, I first went down there in the early 1990s with a group of lawyers led by Massachusetts-based Ecuadorian named Cristobal Boniface, and we went down with doctors and lawyers to investigate what we had heard was this awful catastrophe. And so began a journey that I've been on now for many, many years, starting just after I went to law school. We filed the suit in 1993. We won the suit in 2011. And ever since then, we've been trying to collect the judgment because Chevron won't pay. And I personally have been having to deal with the attacks they made against me and other lawyers here in New York, where I've been under home detention now for 16 months on a misdemeanor for which no lawyer in U.S. history has ever been locked up for even one day. So it's an extraordinary situation. I think it's really the politics of corporate power and using our judicial system to attack, corporate accountability advocates and really trying to use me as an example to intimidate all people who engage in this work. But that's where things stand now. I live with my wife and 14-year-old son. And, we're strong, we're resilient, and we get what's happening. We have a fair amount of support. I have some great lawyers, and we're hopeful we'll get through this. And regardless, the larger case lives on in terms of enforcement actions in other jurisdictions that are being used to try to collect Chevron's assets to force them to comply with the judgment.
Great, thank you. And we're going to dive deeper into those issues and especially, what led up to your incarceration in essence, and also what's happening on your behalf and what are some of the solutions that people can involve themselves in. So these communities and these indigenous peoples, they continue to suffer from these oil spills and these leaks. How so? What's happening to them today?
It's as bad as ever. I mean, basically, the pollution has a cumulative impact over time. The exposures to the toxicity, to the toxins are in the air, in the water, food, in the environment. So the people who live in this area generally are exposed multiple times a day to cancer-causing toxins. And, ever since Chevron left in the early 1990s, there's been virtually no actions to clean up, mitigate the impacts of their deliberate systematic pollution. There's still billions of gallons of, toxic oil waste in this part of the Amazon in the environment. And the state oil company, Petroecuador, which took over Chevron's operation, continues to some degree to engage in some of the same practices that continue to contaminate. And the pits that Chevron built in the 60s, 70s, and 80s are still there polluting the water today, and the air and the groundwater and the soil. So the rates of cancer are off the charts. If you look at the basic independent health evaluations of cancer rates in the region, there's probably been thousands and thousands of people who have died of cancer. You can't go into one of the communities and, if you ask people, does anyone know a family member who's died of cancer? And literally 90% of the hands shoot up. It's just been devastating, and it remains devastating. There was one working nurse in the region, Rosa Moreno, who passed away in 2017 of cancer. She took care of so many little babies who got sick or had cancer, childhood leukemia, which you almost never see anywhere in the world, is off the charts, according to these health evaluations. And it's really a humanitarian crisis. It's a public health catastrophe. And I think it's essentially a crime of what's called ecocide, which is kind of a new thing in the law where that is trying to get sort of acceptance as the fifth atrocity crime, after genocide and crimes against humanity, war crimes and the like. And it's basically, destroying the natural environment in such a way that people who live in it can't sustain themselves. And that's really what's happened in Ecuador. People are dying left and right from their exposures to the oil contamination, while Chevron spends literally $2-3 billion on dozens and dozens of law firms and hundreds of lawyers to just try to muck up the ability of our team to collect on a judgment that the Ecuadorians legitimately won in the courts of their own country where Chevron wanted the case to be held. So it's a very, very bad faith, a form of really judicial treachery and trickery.
Yeah.
And Chevron's paying massive sums of money to the legal profession, to the big law firms, to block the ability to collect this judgment. And part of that strategy is to attack me.
Yeah, and we'll get into that too. And just one thing I wanted to point out that stuck with me when you and I spoke previously is that there's no word for cancer in the indigenous languages down there.
That's correct. Historically, there's no word for it because living in the forest, there was no cancer. I mean, cancer is caused by exposure to chemicals and industrial chemicals and heavy metals, and cancer was unknown before Texaco showed up in the mid-1960s and started dumping, oil waste into the rivers and streams. So
Yeah.
That's true. There was no word for it. And unfortunately now the indigenous peoples have had to create a lot of new words that were formerly not in their vocabularies.
And you had said that Chevron has not offered any form of rehabilitation or reparations, but there's allegations that Texaco did provide remediation supervised and approved by the government of Ecuador. In addition, they also argued that Petroecuador, the state-owned oil company and partner of Texaco, is actually the one that's responsible for the oil spills and the dumping, and not Chevron, who bought Texaco.
Yeah. That's what they say. In terms of the first argument that there was a cleanup, Texaco claims it spent $40 million in the mid-90s on a cleanup. $40 million is maybe 1/10 of 1 penny on the dollar of what they really owe. And I don't know where the money went, but it didn't go to a cleanup. And they took a handful of 1,000 open-air waste pits that are unlined, from which they run pipes into rivers and streams to empty out the toxins into the waterways. And they covered them up with dirt without cleaning them out. It's like treating cancer with a Band-Aid, basically. And the blaming Petroecuador, that is the state oil company, is, to us, it's a non-starter, because Texaco, now owned by Chevron, was the exclusive operator of the oil fields. And under customary law relating to oil field operations, the operator is 100% responsible for the environmental damage. The operator makes all the engineering decisions, the production decisions, and Texaco exclusively made the decisions to pollute in violation of their contractual obligations, in violation of Ecuadorian environmental law, and in violation of their duty to people who live there to treat the environment and the people with proper care so they wouldn't harm them. So we believe Chevron is 100% responsible for the damage that Texaco caused and continues to cause by having abandoned, these 1,000 waste pits and really left the area in a very destroyed, poisoned kind of state. It doesn't mean, by the way, that Ecuador's oil company isn't blameworthy, because they've done some improper practices as well when they took over the fields after Texaco left. But the lawsuit is about what Texaco and Chevron did during the time that they operated and its ongoing effects.
Steven, the lawsuit originally started in New York in the 1990s, and then it was moved to Ecuador in the 2000s. Can you explain what took place during that time and why they had this move from New York to a totally different country?
Sure. So the Ecuadorian plaintiffs, that is the affected communities who brought the lawsuit, didn't trust their own court system, because Texaco had been, dumping literally millions of gallons of waste into the waterways on a daily basis for years. And they never had been held liable for even $1 of damages during that entire time. So the people didn't trust their own court system. They wanted to sue in the United States. But once that happened, suit was filed in November of 1993 in federal court in New York. Chevron's main defense was, no, we can't sue up here. This case is properly heard in Ecuador, because that's where the damage occurred. And we argued, no, it's properly heard in the United States, because that's where the decision to pollute was made. That took literally 10 years of time for that issue to sort itself out in various courts. Like, the Ecuadorians were fighting to get into the courthouse in New York, which is where Texaco's global headquarters was located this entire period of time. And Texaco kept trying to block them from getting into court. And ultimately, Texaco, by then Chevron had bought Texaco, they won that battle, and they were able to send it down to Ecuador, surely thinking that they could quickly get the case dismissed for political reasons, just because they enjoyed so much influence in the country. And they had polluted with impunity for, by that point, for 30 years, and they never even had to deal with one lawsuit against them. So I think they thought we would go away if they were able to move the case to Ecuador. And obviously we didn't. We reorganized ourselves, and we started working with a group of great Ecuadorian lawyers, created a real international team led by the local lawyers in Ecuador. And we refiled the same lawsuit as much as we could under Ecuadorian law in 2003. And then the case started up. It was extraordinary. Texaco's first line of defense is they were trying to avoid the entire trial. And in October of 2003, it started in a town called Lago Agrio, which was, the epicenter of where Texaco first found oil in Ecuador. Lago Agrio in Spanish is the Spanish for Sour Lake, which is the name of the town in Texas where Texaco's headquarters was.
So they basically went on to indigenous territory and created a town around the wells that they built. And they called it an English name after a town in Texas. In the meantime, they displaced most of the Kofan, who had to move deeper into the jungle to avoid the industrial development and the pollution. So we were back in Ecuador, and Chevron had agreed to accept jurisdiction in Ecuador as a condition of the case moving from New York to Ecuador. And the first thing they did on the first day of the trial was they tried to claim the court had no jurisdiction over them. And so began years and years of bad faith litigation. I mean, they just do anything they can to get an advantage. They change their position, they lie, they threaten judges. They tried to put sand in the gears of justice by filing literally hundreds and hundreds of duplicative motions, asking for the same thing, trying to tie up the court. And, their first goal was that there not be a trial. Once we overcame that, they then tried to sabotage the trial that we had been seeking for all these years. And they did that just by trying to file paper and take advantage of their superior resources and their law firms to just get in the way of the case and obstruct it, sabotage it, and hope we would run out of money and go away. So that took 8 long years, and ultimately we did win a judgment against them in 2011, which was a huge historic victory.
Let's hold it right there. We're going to take a break. We'll be right back to talk about that historic victory and then also a little bit more on that 10-year history. So come right back.
Hey listeners, quick break here. We hope that you're enjoying Eco Justice Radio. Stay connected by subscribing on all major podcast apps and visit our website ecojusticeradio.org to check out previous shows and guests and get connected with us on social media for extended versions of many of our interviews, as well as other benefits. We encourage you to become a member of our Patreon. Today you are listening to a special encore presentation of Defending the Amazon, The Fight for Justice with Steven Donziger, with host Jessica Aldridge and guest Steven Donziger, a New York-based human rights attorney.
So Steven, you were just talking about what had happened during those 10 long years from 2003 to 10 years later to having this trial down in Ecuador to get this ruling on what Chevron now owes for the Ecuadorian people due to the toxic wasteland that they have created down there. I think it's also important to note that and remind our listeners or those that may not know that during this time, the Ecuadorian government under President Correa revised the constitution to be the first country in the world to codify the legal rights of nature. And did that have any effect on the outcome of the case as well? And then maybe just talk a little bit again about what that outcome was. I know that there was a settlement of 18.5, but then it was reduced to 50% of that in 2.5 years later. And why is that?
Yeah, so in the middle of the trial, Ecuador elected a president who was a nationalist and educated with a PhD in economics in a U.S. university. And he basically set kind of a tone for the country that I think allowed the court system to do its job properly, that is, to become neutral, to analyze facts, rule on legal questions without being intimidated by corporate power, the oil money, interests. And I think that had a great deal to do with our ability to get a fair trial in Ecuador, which Chevron continually tried to deny to us by trying to, again, throw sand into the gears of the court system, threatening judges, filing motions, threatening to put judges in jail. I mean, it was, one thing I quickly learned as a young lawyer is, while lawyers are trained to go to court and use the law to achieve a certain outcome, the lawyers for Chevron were trained to just look at the court system as just like a tool of their own power, a system to try to bend to their will, as opposed to a system to try to litigate within a fair manner. And they were constantly threatening judges. They were constantly violating Ecuadorian procedural law and abusing the system as a way to try to delay any final resolution because the evidence against them was utterly overwhelming. And there were 64,000 chemical sampling results from dozens and dozens of their former well sites that proved massive amounts of contamination, sometimes 200, 300 times over acceptable regulatory norms in Ecuador. I mean, there were just some sites were just like almost pure oil in the soil. They had created just a terrible, terrible environmental problem. And they knew they were basically toast legally. So they tried to just block the trial from finishing by trying to constantly delay it.
Why was it that it was $18.5 billion, but then 2 years later, they didn't owe $18.5 billion anymore? They only owed $9.5.
That's a great question. So in the law, there's something called actual damages, and then there's something called punitive damages. Actual damages, in theory, is the amount of money it would take to do the cleanup, to correct the harm that they caused. Punitive damages is the amount of money that the court would impose on top of that as punishment to teach the company a lesson so it never commits the same, harmful acts again, and also sends a message to others in the industry that, it's not worth it economically to try to play these types of games. So we won actual damages in the amount of approximately $9 billion, and then the court doubled that. They added another $9 billion for punitive just because Chevron had behaved so recklessly and deliberately polluting, and also because they had abused the administration of justice, by trying to obstruct the trial process. And when Chevron appealed the decision to Ecuador's Supreme Court, the Supreme Court knocked out the punitive damages claim, claiming it had no basis for it in Ecuadorian law. I mean, we respectfully disagree, but it had the effect of having the amount of damages to the amount of the actual damages, which is $9.5 billion. With interest, it's probably up now to around $12 billion. But that's the reason they reduced the damages award.
And after the 2011, right, the decision came in 2011, Chevron immediately countersued, which was presided over by Judge Lewis Kaplan, who's from the Federal Southern District of New York. So this is going back to the United States. And during the countersuit, the Judge Kaplan, asserted that the oil giant was, quote, a company of considerable importance to our economy that employs thousands all over the world, that supplies a group of commodities, gasoline, heating oil, and other fuels and lubricants on which every one of us depends on every single day. So given this reasoning, he made a sweeping worldwide injunction preventing the enforcement of the Ecuadorian ruling against Chevron. How is it that a United States judge has that much international overreach?
Well, that's a great question. The fact is the judge doesn't have that kind of authority, and he totally overstepped his authority, and he was reversed on that decision very quickly by the Federal Appellate Court in New York. But the fact he actually tried to do that is just astonishing on so many levels, and really shows you the level of arrogance of not only Judge Kaplan, but you see this time and time again where U.S. courts are trying to sort of reach their long arms into other parts of the world and arrest people and determine what's right or wrong for people in other countries. The idea that a trial judge in Manhattan, in a completely truncated proceeding with no jury, he excluded all the evidence that the Ecuadorian court had accumulated to find Chevron liable. Wouldn't look at any of it. Would only look at this one witness to whom Chevron had paid $2 million, who admitted lying repeatedly, claimed I was in a bribery plot to bribe the judge in Ecuador, which is completely false. There's no corroborating evidence. It's been rejected by 29 appellate judges in Ecuador and Canada, that notion that that's what happened. But he wanted to destroy the case. And he's tried to do it in different ways over time. And one of the ways is he tried to create a global injunction from his Manhattan trial court to basically dictate to any judge in the entire world, in any country that the Ecuadorians might think of going to try to force Chevron to comply with the law and enforce their judgment against Chevron's assets. He tried to prevent all of them from even entertaining an enforcement action. But what authority does a New York trial court judge have over a judge in France or England or Canada or Brazil or Argentina or Indonesia or Australia? I mean, it's just crazy to even think about. And he was quickly reversed. But it really gave you a sense of his degree of arrogance. He's a former tobacco industry defense lawyer. That's what he was doing before he was appointed to the bench by Bill Clinton. And I think that he sort of has taken it on as part of his life's mission over the last 10 years to try to just protect Chevron, destroy the case, and use it as a vehicle to try to intimidate human rights lawyers and human rights campaigners and environmental justice folks and corporate accountability people and people who care about indigenous rights, he wants to use this case to try to discourage that kind of work, which, as you know, is so vital to the well-being of so many people, not to mention our planet. This is critically important work. So he really overstepped his bounds. And in my opinion, he continues to overstep his bounds, and he continues to be challenged. I think he's isolated in terms of all the judges that have looked at this. And I think one reason why he has gone after me, and he's the person most responsible for me being in house arrest right now, is because we have continued to challenge him and call out what he did as wrong. Wrong both factually in terms of accepting paid Chevron witness testimony from an admitted liar, as well as procedurally to, really abuse the process to try to let Chevron. The reason I'm in house arrest, just to be clear, the ostensible reason is because he ordered me to turn over my computer and cell phone to Chevron, basically the entire case file. And that's unheard of. That's just, lawyers don't do that. I'm litigating a case. So I told him, look, I can't do that. I've got to appeal that before I turn over anything. I'm a rule of law person. I always go to court. I'm respectful. I believe in the law. I get that the system is structured to favor the wealthy, whatever. I accept that. I go in and I fight for my clients. But the idea that any lawyer will be ordered by a judge to turn over his computer and cell phone to adversary counsel has never happened before in this country. So I was well within my duties, my ethical obligations to my clients to appeal it. But while it was on appeal, he got so mad at me, he charged me criminally with criminal contempt of court while my appeal was pending of his order that I believe is unlawful. And by the way, that appeal is still pending. So it's unclear whether his order is lawful or not. In the meantime, he charged me with criminal contempt and had me put under house arrest, where I've been sitting here for 16 months. There's never been a lawyer in New York, Jessica, who's ever held pretrial on a criminal contempt charge for even a day. They're treating the case as a misdemeanor, meaning the maximum sentence, if convicted, is 6 months, as a way to deny me a jury for the second time. And they're trying to use the case to force me into prison for 6 months with no jury. But I've already been in my home for 16 months. And the longest sentence ever given a lawyer in New York for someone actually convicted of criminal contempt of court is 3 months of home confinement. So, they're punishing me right now without a trial. It's a violation of our Constitution, I believe. It's certainly a violation of international law. International human rights groups have condemned it. It's wrongful. Look, there's lots of activists and lawyers around the world who were in prison and some of whom were actually murdered because of their legal work and political work. So I want to keep this in perspective. But for the United States of America, this has never been seen before. And I think that's what's most concerning for all of us who care about, free speech and the right to advocate and the right to hold corporations accountable for their wrongdoing.
I want to break down some of that. Two things. I want to talk about this, the guy who lied, this judge who said that you were ghostwriting or I read that somewhere that you told him what to say in the Ecuadorian case. And then I also want to talk about how Chevron's coming after you and the amount of money that they're saying that you owe, the cases that they're bringing against you. So with this individual, Albert Guerrera, who's a judge, Chevron filed a civil case alleging that the $9.5 billion judgment had been secured through bribery and fraud. Backing the company's claim was an Ecuadorian trial judge, is the guy that I think you were speaking about, Albert Guerrera, who testified that he'd been paid by you to write the eventual ruling against Chevron. And you were accused of engaging in obstruction of justice, witness tampering, judicial coercion, and bribery in obtaining the judgment. Can you expand upon that? Is that true? Is that what the case they brought up against you?
So, let me break it down. This was a retaliation case in which they sued me under the civil racketeering statute, which was passed by Congress to target the mafia. So the basic theory was that I and the other lawyers and the consultants and people who won the judgment against them had engaged in racketeering, that the judgment, the entire case in Ecuador that we had worked on for years and years and years and won, based on voluminous scientific evidence affirmed by 6 appellate courts, 29 judges, was somehow a sham. And as part of their retaliation, they tried, this sort of gets to the title of your show, they wanted to criminalize me. Well, they couldn't prosecute me in the normal course because no prosecutor would take the case because this was all bogus. So they went after me in a civil lawsuit. They initially sued me for the most money anyone has ever been sued for in U.S. history, $60 billion, which is treble damages on the initial judgment. When you get sued for money in a civil case, you're entitled to a jury. They didn't want a jury to look at this false evidence, so they dropped all the money damages claims on the eve of the trial, knowing Judge Kaplan, who had signaled to them he was on their side, would rule against me. And Judge Kaplan did that partly by excluding all of the environmental evidence that proved Chevron's guilt in the Ecuador case, and also by letting Chevron pay this guy, Alberto Guerra, $2 million to come in and claim that I approved a bribe of the trial judge in exchange for being able to ghostwrite the judgment. It's false. There's no corroborating evidence except the words out of his mouth. Chevron got emails and computers at that time from me, from the Ecuadorian lawyers. There's no evidence of any communication with the judge. And there is evidence, forensic evidence, that the judge, wrote the judgment himself over a period of 3 or 4 months by opening and closing a Word document over 480 times. And the document became the judgment. So this was just all made up by a paid witness. They never would have put this before a jury because it would have been rejected. That's why they dropped all the money damages claims so Judge Kaplan could just decide the case alone. And he reverse engineered the outcome. And again, it's been rejected by 29 other judges. I don't know what more I can say except all of those allegations that you just read were derivative of this lying witness. In other words, because Judge Kaplan found that I bribed the judge, which again didn't happen, he also found that the money that I had transferred from my law firm to my clients in Ecuador for case expenses was part of wire fraud, like wiring money to Ecuador, because he found that the case was a fraud, was to him a felony offense. Getting investment money in to fund the case was money laundering. So he just created all these so-called crimes in an effort really to criminalize me and others who had worked on the case, criminalize human rights lawyering. And he allowed Chevron to take a statute meant to target organized crime and use it against a team of human rights activists. And the only way that could work is if he let them, charge us as if we were an organized criminal racketeering conspiracy for winning a multi-billion-dollar judgment against Chevron in a court of law in Ecuador that, again, has been confirmed by 6 appellate courts. So it's really an extraordinary, audacious thing that they did. I think what they did is in and of itself the racketeering conspiracy, not what we did. I think in any fair court system in any country that really truly respects the rule of law, they would never be allowed to even bring these allegations into court. And having done so, they would really be held fully liable, because I think what they've done is in itself criminal. And again, is the true racketeering in this case. And it's designed to protect Chevron's money, and it's designed to protect the fossil fuel industry writ large, which is an industry that, as you know, is often pollutes as a matter of its business model and leaves taxpayers or vulnerable communities with the bill after they, drill for oil in a certain place and leave with the profits. So ultimately, it's important people not get too distracted by what happened to me. I'm hopeful I'll get through this. There's more and more people. 55 Nobel laureates just issued a statement on my behalf, and 37 bar associations have filed a 40-page judicial ethics complaint against Judge Kaplan. It's all in the record. You just have to read it to understand what he really did. And I'm hopeful I will get through this. But one thing I do want to emphasize to your listeners is the case goes on regardless. There are other lawyers working on this. This is not my case. It is ultimately not about me. It is about what Chevron did to the indigenous peoples and the rural communities in Ecuador who still suffer to this day, many of them dead already, others in danger of dying because of oil pollution. That's what this case is about. Trying to criminalize me is just a way to distract attention from the environmental crimes that Chevron committed. I hope I will get through this. I'm confident I will, but regardless of the outcome of my personal case, the larger case will go on. Chevron faces enormous risk for what they did, and they are being held accountable. And I want to emphasize that. That is the main point.
Hey listeners, quick break here. We hope that you're enjoying Eco Justice Radio. Stay connected by subscribing on all major podcast apps and visit our website, ecojusticeradio.org, to check out previous shows and guests and get connected with us on social media for extended versions of many of our interviews, as well as other benefits. We encourage you to become a member of our Patreon. Today you are listening to a special encore presentation of Defending the Amazon, The Fight for Justice with Steven Donziger, with host Jessica Aldridge and guest Steven Donziger, a New York-based human rights attorney.
Steven, to help people better relate to your situation, you are facing similar limitations as, I would say, for people to understand, like Julian Assange. How restricted are you in house arrest currently, and what are some of the other limitations that have been imposed upon you that we haven't previously spoken about on today's show?
Well, okay, so I wouldn't compare myself to Julian. I think he is in a very, very difficult and unfair situation in Belmarsh Prison, and outside London. I'm in my home, and as bad as it is, I still am in my home. But the basic restrictions are significant. First of all, I'm a lawyer who has done nothing wrong. And for a judge to charge me with criminal contempt, Judge Kaplan did, and he appointed his friend Loretta Prescott to be the presiding judge. She's a member of the Federalist Society, which Chevron is a major donor. He brought the charges to the U.S. Attorney's Office. They usually prosecute cases, and they turned down his case. He then appointed a private law firm called Seward and Kissel to prosecute me in the name of the government. Seward and Kissel, it was disclosed 7 months into this after they had pushed for my home detention, actually represented Chevron as recently as 2018, still represent Chevron to some degree. So you basically have a judge with financial ties to Chevron, a prosecutor with financial ties to Chevron, and Kaplan himself, the charging judge, has disclosed in his public financial statement that he has investments in a mutual fund which owns Chevron stock. These people are conflicted, and this case is, should never have been brought, and I think is severely tainted, and that's why they're denying me a jury, and they're trying to basically abuse their power, meaning Judge Kaplan and Judge Prescott and the prosecutor, who, by the way, is getting paid by taxpayers at the rate of $300 an hour and has already billed, we estimate, around $400,000 to prosecute me on a misdemeanor. A misdemeanor. There's something really off about this. I would challenge anyone of your listeners to find me one person in the United States other than me who's charged with a misdemeanor, who has no criminal record and is under pretrial detention in his or her home or anywhere. I think I'm the only one in the whole country. On top of that, they imposed an $800,000 bond on me, which luckily a friend of mine put up as security. But the $800,000 bond is higher than 3 of the 4 cops who killed George Floyd. And here I am fighting for the human rights of people in Ecuador, effectively with success in a case that's been validated by Ecuador's Supreme Court. And I'm in home detention for 16 months. There's no proportionality.
Yeah, and you literally can't even go to the rooftop garden of your building. You've been disbarred without a hearing. They've frozen all of your bank accounts and I think stolen your money. And now they're criminalizing your reputation. You're also married with a son, correct? So this is also affecting their lives.
I mean, if someone said, well, what's Chevron's strategy on the case? I think it's ultimately designed to get anyone working on it to no longer work on it, to basically give up, to leave the affected communities in Ecuador defenseless without lawyers, because Chevron knows if there's no lawyers, there's not going to be a case. So by attacking me, they're attacking the whole idea of lawyering. And of course, it affects one's family. I mean, that's another pressure point that they try to bring to bear. They want my son upset about seeing his dad with an ankle bracelet. By the way, I'm not just sitting at home. I've had an ankle bracelet on my left ankle that is, I call it the Black Claw. It's about the size of a garage door opener. And it's never been taken off since August 6, 2019. I shower with it, sleep with it, eat with it, walk with it when I can get out. I do get out on occasion with the permission of a court officer to go to legal meetings, medical appointments, or school-related events for my son. And it's sort of destabilizing because like every time you crawl into bed, you're like, oh my God, is it going to go off tonight? Because it seems to sort of have a mind of its own. Although that's improved lately because they gave me a new one with, I think, is a higher end kind of ankle bracelet, which, by the way, tracks my movements 24/7. And the technology exists, by the way, to eavesdrop on conversations through the ankle bracelet. I don't think that's happening with me, but it's all just kind of is a real intrusion into the sanctity of one's privacy in one's home. And yeah, it's really weird. You know, my son, he's 13, 14 years old, trying to tell his friends my situation is complicated. It's very stressful. And also, you know, on the financial front, by locking me up, I mean, Judge Kaplan has deprived me of an ability to earn a living. He orchestrated my disbarment without a hearing based on these false findings, based on the paid Chevron witness, which I'm challenging. And you might remember I said they sued me for $60 billion, but on the eve of trial, they dropped all those damages claims to avoid a jury. So Judge Kaplan, after he ruled against me based on this Chevron paid witness, then allowed Chevron to pursue me for $32 million in their own legal fee. And he's ruled that I owe them millions and millions of dollars that I don't have. So I'm essentially bankrupt. And based on those rulings, which I've appealed, but even though they're under appeal, he authorized Chevron to seize all my money and freeze my bank accounts. So I'm completely dependent now on my wife and my legal defense fund, which is a good way to tell people that, you know, I'm 59 years old with a wife and a son, and I'm just flat out wiped out. We have a fund that's held in trust in a law firm in Seattle called Friedman Rubin. And if people wish to help me, and the people of Ecuador, because the fund is used to pay household expenses for my family, as well as legal fees for lawyers involved in the case, which, by the way, are modest. I mean, most of the lawyers now are working pro bono. But you can go to a website called DonzigerDefense.com. It's one word, DONZIGER defense.com. And you can learn, there's a bunch of articles about the case on the website, and you can see all the people who are supporting. And you can also make a donation electronically. If you prefer to send a check, there's an address on the website. But again, it's DonzigerDefense.com. And if you want to help but aren't in a position to donate, go to the website anyway. There's a button where you can click on and join the campaign, and you'll get newsletters. And on occasion, we ask people to take action, you know, contact a congressperson or the ethics body in the court, that kind of thing. And you can participate in this campaign. We've already gotten 16,000 people to sign up, and we want to grow this thing because, you know, this isn't just about me in this case. We want to grow this movement to make sure that the affected communities in Ecuador collect on their judgment and they're able to implement the cleanup that will save the environment and save lives down there.
And Chevron even threatened the communities in Ecuador with a lifetime of litigation, as you have right now, almost a lifetime of litigation, right? And they said if they keep fighting, if they keep asking for the money that's owed to them, that Chevron's just going to bury them in litigation. So and so what you're talking about is how can our listeners support in that action, you know, making sure that Chevron, you know, is held accountable, and that any finances that are coming up, that there's this help.
Exactly right. And let me be clear. So, because, you know, I feel like this is way too much about me. There's a lot of lawyers working. There's a lot of incredible lawyers defending me in my particular case, including Lauren Regan. I don't know if you know Lauren from the Eugene, Oregon-based Civil Liberties Defense Center. You can go to clbc.org and learn about her organization. They're specialized in defending protesters from SLAPP lawsuits. And if you can help out her organization, it's a nonprofit, that would also be good. And then here in New York, I have a very well-known lawyer, defense lawyer named Ron Kuby, who used to practice with Bill Kunstler. I don't know if those names ring a bell, but these are old, aggressive defense lawyers. Marty Garbus, legendary civil rights attorney. Charles Nesson is one of my old professors at Harvard Law School. Rick Friedman, who has stood by me for years on a pro bono basis. Zoe Littlepage, two of the best trial lawyers, I think, in the country. So we have a lot of people fighting hard, and Chevron's threat to bury us in a lifetime of litigation, I think, is failing, because that threat is premised on us just, oh my God, a lifetime of litigation. They have unlimited resources. Why are we even doing this? Why don't we just quit? rather than quit. People are really redoubling their efforts. Our team is extremely determined. Chevron faces massive risk. And I think it's important to point out before we end our discussion here tonight that the Ecuadorians have won the case. And see, one of the things that happens when you focus on me and my plight is it sometimes can be demoralizing. It almost plays into Chevron's narrative, right? Like that it's about me and about their attacks on me. When what it really is about is this great historic victory against all odds that the indigenous peoples and the rural farmers in Ecuador won against Chevron in a court of law, fair and square, playing by the rules. Chevron hates that. The entire fossil fuel industry hates that. So they threaten people and they say, rather than pay the judgment, we're going to spend $2 or $3 billion on 60 law firms and 2,000 lawyers to fight you guys. And we're going to criminalize you. And we're going to find a judge who's sympathetic to us, who's going to screw you. And isn't it ironic that we, meaning the Ecuadorians, showed up here in New York in federal court in 1993 trying to get justice? The courthouse doors were closed. They were told to go down to Ecuador, which they did. After winning the case there, Chevron then comes back to the same court that shut the courthouse doors to the Ecuadorians in 1993, the same court, to file this racketeering lawsuit against me and the Ecuadorians. And then the courthouse doors are suddenly open to them. And, I will say this to all of us who care about the environment. I think there's a real neglect on the power of courts to mess up the environmental movement. I mean, you're seeing this, and you're going to see this more and more now with our Supreme Court, now that it has a 6-3 conservative majority. There's a big issue now whether climate change lawsuits over damages caused by climate change against the fossil fuel industry can be heard in state or federal court. That's a big legal issue. The industry's trying to get them all in federal court where the judiciary is the judges are much more conservative and it's harder to win. And that question is now before the U.S. Supreme Court with Amy Coney Barrett now on the court. And the ability of the Trump administration to use the Federalist Society, which is Chevron funded and gets major donations from a lot of corporations and law firms, to stack the federal judiciary, to put conservative, anti-regulatory, pro-fossil fuel judges into the court system, is making the ability to combat climate change really much more difficult. I mean, it's manifesting in our case with regard to what's happening to me. But luckily, our case is an Ecuador judgment being enforced in countries like Canada, so it doesn't have to do with the U.S. judicial system. But people need to pay more attention, in my view, to what's happening with our judiciary.
The effects of Chevron and their extraction of oil, the plight of the indigenous people in the Amazon, it's not just central to just the Amazon. It's also that material is being shipped to the United States to be refined. And in El Segundo in Richmond, California, they are presently importing lots of oil from the Western Amazon. In fact, El Segundo, which is in Southern California, is the largest processor of Amazonian crude in the world. So we also have some of the largest rates of asthma and illness in the United States in those areas. El Segundo is the largest processor of Amazonian crude in the world. Should Chevron, should they be allowed to continue conducting business in the United States, considering their flouting of the Ecuadorian judgment and the refusal to conduct any type of cleanup and reparations in the Amazon?
That's really happy you raised that question, Jessica. I think that's really important. I mean, the philosophical question is, as a society, if a company is a serial polluter and does it deliberately, as Chevron did in Ecuador, and is held accountable in a court of law and refuses to pay the judgment, should they just be allowed to operate as if they're a company in good standing and go around the world, whether it be California or Nigeria or Israel? Chevron just entered the Israeli energy market, and just be allowed to bid on projects as if they're a company in good standing. I mean, I think people need to think about that, because I don't think a company should be allowed to go exploit vulnerable people in the Amazon, pollute systematically and deliberately, run away with the profits, and leave behind an environmental calamity that's killing people, and leave the very people who were poisoned with the cleanup bill. Because that's what's happened in Ecuador, because they won't pay it. So the people are suffering all the consequences of the fact that Chevron externalized its cost of production into the environment. And literally people are dying. So how can this company come into California and take the very crude that is produced in Ecuador, where it caused this massive calamity, and refine it in California, creating all sorts of pollution problems in California, which we see in the El Segundo refinery up in Richmond, and that refinery where in 2012 there was a big fire and 15,000 people in the local community had to go get hospital treatment because of respiratory problems. I mean, these are mass industrial poisonings, whether it be in Ecuador or Richmond. And our regulatory system and our court system is simply not up to the task of enforcing the law to such a degree that they don't have an incentive to keep behaving in this reckless or deliberately criminal manner, as in the case in Ecuador, where they actually made a decision to pollute, as opposed to it being an accident. So, I would encourage people to learn about this and read about it. There's a lot of pretty good articles out there, which you can get on that website, Donziger Defense, some of which you can get on that website. Chris Hedges, a Pulitzer Prize-winning journalist, just wrote a fabulous story about this on the Sheer Post website. And there's just a lot more people focusing on this. On The Intercept wrote a great story. The Nation. Oh, by the way, people can get more immediate updates by following me on Twitter. Forgot about that. I sort of got onto Twitter a couple of years ago, and I have a fair number of followers. My handle is @SDonziger, and you can get a bunch of these articles if you just go down my recent tweets, and there's links to them and that kind of stuff. So follow me on Twitter if you can, and you can get regular case updates. But again, the important point is the Ecuadorians have won the case. Chevron is running scared. That's why they're attacking me. That's why they're hiring lawyers all over the place to try to obstruct the collection of the judgment. But I believe ultimately the Ecuadorians will collect the judgment and be able to do a cleanup.
Thank you, Steven. Thank you for being on the show today. I really appreciate you sharing your story with us and sharing the story of the Ecuadorian people as well.
Thank you, Jessica, for the opportunity, and good luck in your continued good journalism. Really appreciate it.
Thank you. We appreciate you. Thank you to our guest today, Steven Donziger, and thank you to our listeners for joining us. This has been a special encore presentation of Amazon Defenders Criminalizing Activism, the Steven Donziger Case. Be sure to tune in to our other 2 episodes of Amazon Defenders, Part 1, Protecting Biodiversity from Big Oil, and Part 3, Fires, Corruption, and Resistance in the Brazilian Amazon. And please connect with us on social media. You can go to Eco Justice Radio, SoCal 350, and Adventures in Waste. If you like what you heard and you want others to be informed, you know what to do. Subscribe to our podcast, share the episodes, get that shared knowledge out there. You have been listening to Eco Justice Radio, a project of SoCal 350. The show can be found on all major podcast apps and at ecojusticeradio.org. Created by Mark and JP Morse, executive producer Jack Ite, producer Amelia Barras, engineer Blake Lampkin, interview hosted by Jessica Aldridge from Adventures in Waste, and original music by Javier Cadre. And until next time, remember, the power is yours.